I've got to go back to an earlier case, Alice Williams versus Tran, and I see that Tran has just joined the call.
Yes, Your Honor.
Okay. Now, I called your case earlier in the calendar, and since you were not here, I've had the matter reset for March 18th at 9 o'clock. That's 2 weeks from today. So make a docket entry on this one that Ms. Williams will not need to provide further service because Tran is here, and I'm personally notifying the party that the hearing is on March 18th at 9 o'clock. All right, so you can log off, but your hearing now will be heard instead on March 18th at 9 o'clock. And please try to log in immediately at the beginning of the calendar so that your case isn't missed.
Okay, sorry, Your Honor. We thought the case started at 9:30, so that was
Yeah, if you don't remember the start time or the date or anything else, just contact the clerk's office. They'd be happy to give you all the details. Okay. All right. So, Miss Mayfield, where are you? Okay, would you come up to the table? Okay, so when I called your case before,
yes.
I made the comment that the first thing I was going to ask you and Mr. Andrews to address is whether this is a case involving rights to property, real property. And the reason I did that is because under the law, if a dispute between parties involves the right to use property, be on property, where a property line is, who's using it correctly or incorrectly, even if that property is an easement, then the jurisdiction to hear the case is with the Superior Court, not the District Court. And the issues can't be resolved by the District Court in an anti-harassment hearing. It's a different kind of hearing that would have to be heard in a different court. And rather than spend any time trying to resolve your dispute, if it's not a dispute that can be resolved here, I want to get an answer to that so that it can be in the right court so that it can get resolved correctly. So since you brought the petition, Ms. Mayfield,
Yes.
I'm going to turn to you first and ask you why the matter shouldn't be transferred to the Superior Court to resolve there.
I'm not here for the property dispute. I'm here for anti-harassment protection order. I don't know how to put all this because I am not at ease anymore going onto my property alone to repair or to fix because of what happened on the 19th of January. I was up there early morning to measure fencing and gates so that I could replace them and put them back up where they belong and clean up my property. I always felt safe going up there, but I don't feel safe anymore because on that particular morning.
Well, let's don't get into the merits of that part yet.
Okay.
Just, generally, yes, I understand that that's
yes,
what's
so that's why I'm here is to get a protection order that protects me when I'm on my property and to be able to do what I need and want to do there. Right now, I can't.
Okay. Now, has there been, to your recollection, or do you understand there to have ever been any kind of action in any court between you and Mr. Barton or Ms. Malone regarding the property?
There was. Mr. Barton took me to court. I don't believe it was anti-harassment. He took me to court and claimed that I had said and done all these vile things. And my husband, Peter, just ignored it.
Your Honor, I'm getting from one of the.
We went to court and it was dismissed with prejudice so that it could be brought back to court again. But we never did bring it back to court again because we just wanted to live our life and just.
Yeah, and I think I saw that order that had been signed dismissing the case. Okay, so your contention then is that this case that's in front of the court right now doesn't have anything to do with real property. So you're not going to ask me at any point during this case to tell him that he can't go onto an easement or can't use an easement, can't put a sign on an easement, use a gate on an easement. You're not interested in that in any way.
I just want him to leave me alone.
All right. And I'll get any response you may have, Mr. Andrews.
Your Honor, this whole issue arose when my client tried to improve the easement on the property in which he has a legal obligation to, and Miss Mayfield took it upon herself to interfere with that process. Miss Mayfield contention in respects to what she is claiming is her property is property that is the easement. And Miss Mayfield, as I had shown in the supporting material that I filed, and I want to caveat all of this, Your Honor, is with the fact that we were not able to serve Miss Mayfield as the court had instructed through certified mail. She had a note on her mailbox that said vacant property, no mail accepted. So I could not serve her by certified mail. I then tried to have her served by a process server at the expense of my client and was not able to effectuate service because she would not answer when the process server tried to attempt contact twice. Lastly, if the court may see from the Superior Court matter that my client filed, that matter was dismissed because Miss Mayfield would never make herself available for service. Even though she appeared in court, she never actually appeared to get served, and that's why that matter in Superior Court brought by my client was dismissed. So to say that this is not about property, I think is sort of, is it about the use of property? Well, not in my client's mind. It's not, because he's doing what he's legally obligated to do, and Ms. Mayfield has utilized this process to interfere with my client's ability to access and create barriers for him to improve upon and access his property through the easement. So, you know, it's an interesting question that the court has proposed, one in which I wondered if it was going to come up because I wasn't sure what Miss Mayfield's contention was in respects to what her allegations are. Her allegations were specific to 2 points, that being the incident that allegedly occurred on the 19th and the incident that allegedly occurred on the 20th. I addressed those 2 issues specifically with supporting documentation, one in which have the declarations of my client's employer, which states that could not have happened. It was not in any way feasible for that interaction to have ever occurred. And Miss Mayfield has made incorrect or erroneous allegations regarding that incident because my client was at work, 50, 60 miles away at the time that those allegations were to have allegedly occurred. Additionally, my client, in anticipation of sort of this building situation regarding the easement, had filmed in his home Miss Mayfield posting signs on the easement about no trespassing. There's a video and photos of Miss Mayfield taking debris and putting it in an area that essentially in an attempt to block roadway traffic on the easement to Mr. Barton's residence. So I don't know. The question for the court is this about real property? I don't know. But is it, pertain to these 2 incidents? I would say that she's made 2 specific allegations. Regardless, Miss Mayfield hasn't been served, and I was going to ask the court to allow us to serve her electronically to ensure that she has any material that my client, the respondent, has filed in response to this, as to ensure that this hearing is conducted appropriately.
Okay, and here's why I raised these concerns. all the time, and I'll, addressing you too, Ms. Mayfield, both of you. This court hears anti-harassment petitions in the context where people are neighbors. I mean, they live right next door to each other in, like a residential, neighborhood type setting. I know Temple Lake area out there is maybe a little bit different because there's bigger tracts of property and so forth, but just for an example. And all the time there are allegations of different kinds of, conduct, words exchanged, things that people do that, maybe they're intended to harass, maybe they get on each other's nerves. And the court can handle situations like that because you're just essentially arranging or making restrictions on the conduct of parties with regard to each other. And the fact that they live right next door to each other, maybe that is not, that may be how they know each other or something like that, but there's nothing about their property ownership with relation to each other that is in any way tied up with the substance of the allegations. And then there are other cases, and this arises too in this court with some frequency, where not only are the origins of the allegations based in a dispute over property, in other words, the hostility, the actions that are alleged to have taken place, actions like people attempting to stop someone else from using property in a certain way, or claiming a right to be able to use property in a certain way, or attempting to prevent another party by doing things like posting signs or blocking access or anything like that. that is material to the dispute itself. In other words, the dispute between the parties is animated by this property issue, this real property issue. And secondly, any orders that the court may issue in order to address the hostility between the parties is inevitably bound up in their right to use or access property. In other words, if the court were to issue an order, it would have the effect of limiting, restricting, or prohibiting one person to use or access property in order to prevent the dispute from arising again. And and it's an important question to ask and to resolve because, one, it may not be an anti-harassment type case in any event. It may be a different type of case. It may be a quiet title action. I don't know. But then secondly, this court doesn't have jurisdiction to make arrangements in other words, the court doesn't have the ability to decide whose claim to property is the valid claim or not valid. This court can't do it. The Superior Court is the only court that can do it. So the law is written, I mean, the anti-harassment law in RCW 7.105 specifically tells this court that if the matter is going to affect someone's right to property, to real property, that the matter has to be transferred to the Superior Court. Because, and if you think about it, it makes sense, right? I mean, if that issue can't be resolved, then the underlying dispute isn't being addressed. And any order that this court does issue wouldn't really be very effective because that underlying issue still remains unresolved. If you go to Superior Court can resolve all issues between you. So I don't want to, Mr. Andrews, to address your point, I don't want to continue this if all it's going to do is result in confirming my suspicion that this case is totally bound up in real property, and any issues that any orders the court issues would affect people's right to property and would have to be decided in Superior Court anyway.
I believe that may be the appropriate remedy, is that the court dismiss this action and Ms. Mayfield has to file this in Superior Court. And the reason being is and I know Your Honor was not the judicial officer sitting before the court last time we were here, but Ms. Mayfield said, and I don't want to, in summary, she asked if she was going to be able to begin action in doing things on her property. And I say that loosely because, I mean, it's an easement that it runs between both of their properties. And she wanted basically the blessing by the judicial officer on the bench at that time. I believe it may have been Judge Myers, who said, no, well, and said almost the exact same thing. This is this is not about property. This isn't about who can do what or when in respects to property issues. So that, given that statement and what the court has stated here, it would be our position that if that's what Ms. Mayfield's intention is with this property, this is not the appropriate venue.
Yeah, and now I want to be clear too, that I did read, all the parties' filings from the original petition all the way to the latest filings in the case. And I can't separate this into simply, personal interaction issues versus real property issues. I don't think that's possible in these circumstances. And I think it would be, if we were to go through with a hearing and I carefully tried to avoid crafting any order that would, in any way affect anyone's right to property, the underlying issue would not change in any way. And any order that might come out of that in order to try to avoid those issues, I think would be completely unworkable anyway. So my inclination is to do this. I would dismiss the action, and Ms. Mayfield dismissed without prejudice. Obviously, it wouldn't affect your right to file it anywhere else. But I'm not telling you what to do, but I do think that the correct way to address the dispute between the parties here is to go to Superior Court and sort it out. Now, you may want to discuss this with an attorney, and maybe there's a way that it could be negotiated to a satisfactory resolution without having to go to court to do it. But I don't think your time is well spent here, because this court's jurisdiction over the issues you bring here is either very, very limited or not at all. There's none at all.
May I say something?
Yeah.
I do know the difference, and I know how everything reads as being people thinking that it's the property thing. But I'm in my 70s, and to have dogs lunging towards me when I'm just walking on my property is a threat, and it terrifies me. Terrifies me to the point where the day that it happened, I slowly walked up to my car, got in, got up to my home, to the main driveway, got inside my home, and my knees buckled underneath me. I was so terrified and so afraid that I actually urinated on myself, having to clean myself up, pack my bags, and leave the property. I spent the following Monday in court to get the temporary order. Saturday, I went up there to give some things away to my friends. And while they were there, I was asked what I was going to do for the next day or two or the rest of the day. I said, well, I got to go put these signs up so that I can fix what I need to fix up around here. Again, the dogs weren't lunging, but they were present with muzzles on their faces in the front of his gate. Now, when a person is so terrified, they can't even go home and feel safe. To me, that's a separate issue than the property issue. It's an issue of being so terrified. I don't want to be a statistic of a missing person or another Indigenous woman missing or murdered. And that's how I feel when I'm up there, because I don't know what my neighbor is capable of doing. If he's capable of pulling his dogs out on me, what else is he capable of doing? That's why I brought this before the court, not because there's this process of what he believes he needs to do and what I believe I need to do with the property. This is completely separate. And to feel so terrified, even just be in the presence of such a human being, that scares me. My two friends were there. They saw how afraid I was. But I can't even go up there without having people with me now and feel safe in my home. That's why I brought it before your court.
Okay.
And may I speak?
And the issues that you're talking about can be resolved in the Superior Court. In other words, the Superior Court can take an anti-harassment order, which is the type of case that this is, and issue orders as part of it that do affect people's right to property. That's what I'm talking about.
But this
So-
isn't regarding property. This is
Yeah, Ma'am,
regarding.
you can't argue the case on behalf of your friend. It's got to be her. If you're here as a witness, I would hear from you in that context. And
I was
if you're
there
here as a
and I saw
support
his
person,
dogs.
that's fine. But,
I was there and saw his dogs.
okay. No, I'm not, like I said, I'm not,
I-
the preliminary issue, I'm not really digging into so much
Okay.
that, but what I can do is the order that was issued, which is still in effect, can be transferred to the Superior Court and just decided there. That's all I'm saying. It will stay in effect as is, which, I'm looking at the restraint provisions here in the order, and it's still, it directs the respondents, no harm, no contact, no stalking, and stay away, as long as the stay away doesn't exclude them from their property. And that can remain in effect, same as it's been in effect since the day this case was filed in January, until it's heard in Superior Court. And I can have the clerk right here, get a court date in Superior Court, can have the entire thing packaged up as is, no changes, to
I'm
go
not-
over to Superior Court to be decided there.
I'm not prepared right now, Your Honor, to do anything with Superior Court. I don't have the funds for that. I don't have the funds to hire an attorney.
Okay.
When
Well,
Peter was alive, we had the luxury of having his tribal court and lawyers help us. I do not have that because I am not a tribal member. So I don't
that's
have
what
that luxury of paying an attorney or going to court or filing other charges.
No, well, this is what I'm trying to explain to you. The Superior Court will hear this exact case that we have in front of us now, just the same information, the same case, it's the same case type. It's just that it would be effectively be the same thing as if we continued this case here, only the next time you come to court, you're going to be in front of a Superior Court judge in the building next door, where they do have the ability to not only address the issues you're talking about with being afraid of the dogs and thinking that, there's a chance that he's trying to intimidate you and so forth with the dogs, and make decisions in such a way that if it incidentally affects the right to use property, access it at a certain time, whatever the court thinks is the appropriate way to address it, the court can. This court can't.
Okay, I understand.
That's what I mean. So you wouldn't be in a different position in terms of, your case being, just dismissed and then you're on your own.
Okay,
So,
thank you for
Kayla?
clarifying that.
yeah, and I know that's confusing. That's confusing to judges sometimes too, because this law area is a little bit complex and sometimes it's not always clear exactly how it applies. But what I wouldn't want to do is do something wrong that's going to result in an order that's ineffective.
Okay.
That doesn't do what you need it to do,
Okay.
or that causes confusion for everybody later down the line, and then you're just right back in court again trying to straighten it out.
Okay, the other thing, Your Honor, is that mailbox has been closed for over a year. We have our mail going to a different address for a long time because our mail was being tampered with.
I understand that
Yeah.
that happens a lot, and
And
to
so-
make it easier, we're gonna get a date.
Yeah, I'm gonna reach out to.
Yeah, and it might take a few minutes, but
Okay,
we're gonna
that's
do.
fine.
And
then-
then you don't have to worry about that because everybody will have everybody else's information to get, documents and so forth served on each other.
As far as his attempt to try and serve me, my forwarding address is with the post office. I get all of our mail there. So I've not received any kind of notice of it, and I've been watching for it.
Your Honor, she represented to the court that we could serve her by certified mail, which is done through the post office.
That's what I want,
I-
is certified mail.
And Your Honor, except for the fact that the post office through certified mail would have made an attempt to serve at the forwarding address, and
No,
none of that was on file. I would ask,
As far as dates though, we'll get you dates so you don't have to worry about serving those, but I would suggest that you just give each other, right here, right now, like an email address or a definitive way that you can exchange documents so that there doesn't have to
can
be a
mail it to
discussion
me.
at a court hearing.
the mail always comes to me.
Your Honor, and that's what she
That's
said.
my choice. I don't want Mr. Barton having my email address. I don't want his lawyers having my email address. I don't
Well, that's exactly what Miss Mayfield said last time, Your Honor. And unfortunately, when we went to
I
go
stand by that.
to certified mail, it's not, it can't be effectuated because there is not an ability for the post office to do that based on what I filed with the court.
Okay, and you know, I'm going to suggest, Ms. Mayfield, that an easy way to do this is to just get an email address, like a Gmail address, and use that
I'm
only for
sorry,
the
Your
purposes of this case.
I'm sorry, Your Honor, but his papers can come to me in the mail. I was looking for it for the last, was it 28 days? I was waiting for it every single day, even on the weekends, waiting for the mail and for a notice saying you have a certified letter, please come in and get it, signature needed. I would have went and got it. I did not receive anything like that in the mail. I have gone to my post office and I've asked them and they've not seen anything.
Your Honor, we may-
This is
I'm
not.
sorry, but that's just the way it
Right,
is.
this
I'm
isn't
sorry.
something that I can sort out here, but
Yes.
I will tell you that you run the risk of not getting information that you should have for a court hearing. And if you go to court and find out that there was documents that you were supposed to have before the hearing, that can really affect your ability to present the case that you want to present or respond to allegations against you. It's tempting to try to isolate yourself from service of documents, but it is always a bad idea to do it. And I can't sort that out for you right here. You can make your own choices in that regard, but I really think it's in everybody's best interest to be open with each other and easy to exchange information with so that there aren't surprises on the day you walk into court. All right, I'm going to have you stand back. The court clerk will.
I emailed them. I'm gonna have Dustin follow up.
Yeah.
But it's not something we usually get right away. We usually.
Yeah, we'll get you another court date in the Superior Court. And in the meantime, the temporary order that was issued originally on January 22nd will remain in effect until that court date.
Thank
But
you,
they'll
Doc.
let us know when it is, and I'll issue it as soon as I know.
Thank you.
Okay.
And I do understand what you're telling me about the mail and things, but I'm also giving them another opportunity to try and mail it back to me.
Okay, well, like I said, you're going to have to
And if they
work that
don't,
out.
Your Honor, the only address I have is the address that's on record with the court. I went through the post office certified mail. If Miss Mayfield has another address that she can endorse the record, I'm happy to use that address to serve her certified mail.
Need to wait back here.
There's an order. I'll have to get the.
Yep.
Should I go off or turn off my camera and microphone?
Yeah, I'm just getting kind of the basics of this order in place. And the clerk tells me it might be a little while till the Superior Court clerk responds with a date.
And will I have any input on the date? Just because.
No, we won't get any input on the date either. You may.
So we have court date, it's gonna be March 15th, it's a Friday at 9 a.m.
March 15th.
I am, Your Honor, I'm in Philadelphia for a case out of state on March 15th. Is there any other?
We'll see what we can do. We don't set these dates though. They do
No.
over it.
That's why I wanted to be very candid with the court that there are particular dates. The 12th through the 15th, I'm out of state. The 22nd, I'm out of state.
That's the only date they have.
Yeah, they're saying that's the only date they can issue right now. So you're going to have to approach them for a change of date. Okay. Yeah, so the court clerk here will get a Superior Court case number, and we will then send all of that out to the parties. Ms. Mayfield, do we have your contact information so we could send you the notice? 29, and Mr. Johnson, since Mr. Pimentel is your attorney in this case, did he give you any instructions or information about what to do here today?
Yes. He would like to schedule on a day that is not Monday. That's evidently that's a hard day for him.
Okay, it's the only day we do protection order full hearings is Mondays, so that's all we have.
I will let him know, Your Honor.
All right, now also I note here that Mr. Pimentel has not filed any responsive pleadings for you in this case.
Okay, I'll let him know, Your Honor.
All right, now Miss Jordan, I've got a question for you.
Yes, Your Honor.
What I'm understanding is Mr. Pimentel is in another court hearing and wants the case to be continued. If it were to be continued, the temporary order that was issued before would stay in effect until the next court date. Do you have any comment on whether the case should be continued?
Your Honor, I object to that. The respondent has already continued twice and been notified in January, I believe. So I think it would be damaging for me to continue this. It's been dragged out long enough, Your Honor.
Well, Ms. Jordan, I'm not going to say you're wrong about it being long enough. I do see here that the case has been to court. It looks like this is the third time.
I'm ready for my testimony, Your Honor.
All right, what I'm going to do here is I will grant the request to continue so that Mr. Pimentel can be present with Mr. Johnson. However, I want to be clear about this. Ms. Jordan is correct. This case has come to court more times than it should have. And it's been continued at the respondent's request. That we're not going to continue the case again. It'll be a final continuance. This is absent any kind of, personal emergency, of course. And it may be that if Mr. Pimentel's restrictions on dates that he can appear to court mean that he can't be here for any of the available court days, he may need to consider arranging other counsel for you so that you can be represented. These kind of cases and hearings are supposed to be heard expeditiously by courts. And this is really right on the verge of not being expeditious. It needs to be resolved. It needs to be heard and resolved. So, Ms. Jordan, I will extend the order, the temporary order. There'll be no further continuances. And that is particularly true with conflicts with attorney schedules. So, Mr. Johnson, if you're going to be represented by counsel here, you need to be prepared, or your attorney needs to be prepared for that. Okay.
Yep.
All right. So, yeah, let's just do 2 weeks to that. Everybody's been served with notice, and so there's no further need for notice.
Your Honor, may I say something?
Yes, you may.
I believe the respondent has had an attorney previous to when he filed or appeared on the case. I'm sorry.
I'm sorry. Would you say that again, Ms. Jordan? I didn't quite catch it.
I believe that the respondent has had an attorney since previous to the attorney appearing for demand for discovery.
I don't know if that's the case or not. The only attorney I know who's been officially on this case is Mr. Pimentel. I've made it clear here in the order, and the court clerk is going to make it clear in the docket notes that the case will not be continued again for attorney conflicts with court dates. Both cases, Ms. Kashani's the petitioner and respondent, Bridget Marshall and Daniel Cobb. All right. So for all three of you, can I have you raise your right hands, please? And do each of you swear the testimony that you do give in this case will be the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Okay. All right. So in this, the way we're going to do this is Ms. Kashani's the petitioner. She gets to go first and explain her side of it. And then I'll hear from each of the respondents after she's had her turn. Now, I am going to hear the cases together since you're all sort of here together, but I'll decide each case separately. based on the facts. So I don't want you to think one outcome is tied to the other.
Understood.
Now, keep in mind that I have reviewed the petition and I've reviewed all the attached material that's been submitted with these matters. So it's not necessary for you to repeat or reiterate the things that you've already written down. Those are all part of the record and all part of the basis that I'll use to decide the case. But if you want to make any arguments based on that or supplement anything, you can certainly do that. And if you want to refer to any of the material that's been submitted, just refer to the page on the petition or refer to the exhibit number if there's been an exhibit filed in the case. After I've heard from both sides, then I'll make a decision. I'll tell you why I made the decision. I'm going to ask you to just listen to each other, don't interrupt each other. And that's true even if you think the other person's telling me something that's inaccurate or not true. And keep in mind that you either have already told me your side of the story, and I know that, or in a minute, you're going to get a chance to tell your side of the story, and I'll hear your version too. All right, Ms. Kashani, you want to go ahead and start?
Yes, Your Honor. So I'm here for the the anti-harassment for Danielle. I'm not really interested in Bridget's continuing. But
do you want to dismiss that one, or what do you
miss that one for now? I mean,
all right, well, I can certainly do that. If that's your request, I can do that, and we can just go on and deal with only Ms. Cobb.
Yeah, I think I'm gonna move.
Okay. All right, then, Ms. Marshall, your case is dismissed. Ms. Kashani doesn't want to pursue that, so you can still be a witness, though, if you want to. And we'll just deal with Ms. Cobb's case.
Okay.
Okay, so then, Ms. Kashani, just with regard to Ms. Cobb's case, go ahead.
So I didn't get to file the reports that I had called in, but I feel like I'm really not sure where to start. But when I moved in the apartments here was back in 2017 in October, and maybe a little while after I moved in, I would hear Danielle arguing and cussing a lot in the apartment hallway. And since there was an incident where I had called the police on Danielle, I don't know this person. She's just the neighbor that lives behind me with her children. And I had to call the police on her for an incident. And since then, she was like, there was no hi or bye in the apartment complex. So she's where to start. It's just been an incident where recently she has began to leave notes on my door. The other day, my daughter and I was leaving our apartment, and there was two guys at Danielle's door in the back hallway smoking on the stairs. And I had asked them nicely not to smoke in the hallway on the stairs, and they were really nice and said, okay, that's fine. Later that day, I came home, and there was some notes taped on our door that looked pretty disturbing, saying that if we don't like smoke, we need to move out. There's like holes punched in the sign. There was a few signs has been left sent by Danielle, and he also got into my property on my porch when we were sleeping and took some tape and some scissors, and she taped up our door so that we couldn't get out of our front door. There was tape all the way across. I called the police, and the police came out again for that incident, and Then I went to get the papers for the no contact order, and after the police left, she continues to harass. She came by ripping tape off the door, picking up the vandalism that she did, started throwing at my door, bamming on the door, and I opened the door to see who was at the door again, and it was Danielle. I took pictures of her and a video of her cussing at me and throwing garbage, telling me, clean up after your daughter. She cusses me and out in the parking lot in front of all of the neighbors. This morning when my daughter and I was leaving, I didn't have my phone camera to record because when I looked out the window, her car wasn't there. So me and my daughter walked across the parking lot, and Danielle came flying through the apartment parking lot this morning, and in a high speed. I told my daughter, go quick, because we were right in the apartment, and she flew right up to Bridget's sliding door right here, because I live in the front by the front entrance. There's also a back entrance that I should have mentioned before, because if she can enter from the back entrance and park on the other parking lot so that we are not harassed. Also, after I got the temporary order, Danielle, she walks down through the entrance of the first entrance, and she started banging on the wall with her suitcase or something, hitting my wall and saying, oops, ha ha ha, oops. She's told me before in front of my child that she would kill me, or she wanted to kill me. She started a problem with another neighbor that plays with her kids play with my kids. And Danielle came up from her apartment, and my kid was on my porch playing with another one of her friends. And that other lady's little girl was on her porch. And my daughter's friend asked her, can you please go over back to your home? Because she's about 2 years old. And they didn't push her or do anything. And Danielle, she saw that, and she yelled for the other neighbor, come and get your kid. They're bullying her and being mean to her. And then she caused a problem with that neighbor, which me and her were totally fine. There's not been any problems with anyone around here, except for Danielle. And so Bridget was a part of, Bridget and her are some type of friend since, but I'm not sure. I know that all of this is coming from Danielle. She leaves notes. She cusses at us in front of neighbors. I just want her to leave us alone. Don't try to write notes. Don't get into our property. Don't floor past us like you're going to run us over in the parking lot. I mean, if she could park over there, that would be fine. And if she could enter from the back, then it was totally peaceful after the police came out here the third time since I got the restriction order, because she was also out there yelling and indirectly talking to me saying, we're going to find out who the liar is, and so-and-so is going to write a letter, this person's going to write a letter. Like, I mind my business. I have no interest in talking with her. Her children are fine. There's never been no problem with her children. Actually, they have no problem going in the hallway past our door. It's always just Danielle. So I'm probably missing a couple of things, but I have pictures of the notes and videos that I didn't get to submit. I've requested them.
Okay, well, I think I've got a good grasp on, what your complaint is and the basis for your request for an anti-harassment order. So, Ms. Cobb, why don't I hear your side of it? And keep in mind, Ms. Cobb, that all the statements that you filed from other people and everything, I've already read those, as they're already part of the record. Those people won't need to testify. So what else do you want to tell me?
So I moved in February of 2016, and I've lived here for now 8 years. When I moved in, there was no issues with Sheila. Neighborly things. She'd come knock on the door, ask for some saran wrap or foil or a cup of sugar or something like that. There was no issues. Unfortunately, she lost her car to a car fire. I helped her get her child to and from school a few times. I have a great community here where I've lived for a long time and friends with a lot of people in the building, a lot of people on property. I find myself advocating. We live in a low income, high crime rate neighborhood here. My car has been a victim of being egged. Bridget's porch was silly string. The people across the hall from me had their back porch squirted, or their front door covered in ketchup and barbecue sauce. The morning that I awoke to Sheila finding out that her door had been taped shut, the police came to the door. They asked me if I had anything to do with it. There was no findings. I'm a grown woman. I don't have time to be taping anybody's doors shut. I'm not breaking into her property. Let's see, on the day that she filed the order, that boiled over because for days and days and days and days and days, Sheila had been yelling at Bridget about her smoking. Bridget is the one that has been posting the notes. I posted the one note. Yeah, Bridget will tell you, she posted one note. I posted one note on her door after she made my company completely uncomfortable when they came inside and said, excuse my language, that lady back there is a B word. She just told us we have to smoke 25 feet away from the building. I called the office and verified our non-smoking policy, and it is not a non-smoking property as long as they are not on other people's property or in the hallway that they can smoke. They were standing at the end of the stairs because it was raining and the rain blows in on my building on this end where I am on the back side of Sheila. I can't get to my door without walking by Sheila's front door. I'm not going to walk in the mud and walk all the way around the house or put my children through the mud in this weather. There's not a sidewalk that goes all the way around the house. There's not a cemented path. We are at a dead end by the compactor, and I'm not going to park at the beginning of the complex and make my children walk down here. This weekend, I stayed in my house because I was uncomfortable and intimidated at the fact that I can't have a conversation with my friends without her thinking that it's about her. Over the summer, her daughter was out front talking to her friends, and my neighbor Michaela's young one had wandered over, and her daughter had made her cry. So I told Michaela to come get her child. It's not my child. Come get your child. Your daughter is crying. Later that evening, Sheila stepped out on her porch, camera in my face. Come get me. Why are you getting in my business? That's my friend. I'm going to defend her daughter. She has threatened numerous times to get us all evicted. All the time. She threatens to get us evicted all the time. There is no intent for harassment. I am not out here intending to make her feel some type of way. I'm not intending or putting any intent to make her feel uncomfortable in her own home. Not doing that by any means. I'm sorry if she felt that way, but I'm going to defend my home, my children, my friends also. I'm not defacing property. I've not broken into her property. I have not defaced her property or her home, her vehicle, none of those things. And there's been silence for months in regards to her. Her and I know we don't say the friendly, hello, neighborly things anymore. I step to the side and let her walk through. I don't push through her. I'm not aggressive or anything like that. This morning when I drove in the parking lot, she was on the other side of the parking lot. Miss Bridget was sitting out front smoking a cigarette and can tell you nobody drove at her aggressively. Again, I'm not out here intending to intimidate, harass, or anything like this. This is where I lay my head. This is where my children lay their head. I've built a community. All of us back here, we celebrate the holidays together. And I'm just...
Okay, Miss Cobb, I'm going to kind of...
Go ahead.
Stop you
I'm
there.
sorry.
Okay, now I've heard enough. I've read all the exhibits. I'm familiar with all the allegations from both parties. I think there's sufficient record here to make a decision. And I think it's clear. can't find, based on the evidence that's been submitted here, or the testimony that's been given, that there's harassment going on. I know that there's a belief on Ms. Kashani's part that a lot of the incidents and things that she referred to that happened to her door and so forth are attributable to Ms. Cobb, and maybe they are, but the evidence that is not sufficient to be able to conclude by a preponderance of the evidence that Ms. Cobb had anything to do with it. The normal sorts of conflicts between people over things like where smoking occurs or who's kind and polite versus who's rude and obnoxious are not the kind of things that can be addressed in an anti-harassment order. Harassment, people talk about harassment in casual conversation, and the meaning of that word is different than how the law applies the word harassment. It's got a specific meaning in the law, and I can't find that that's the case here. There's clearly bad blood. There's clearly personal conflict here. I can see that. It's obvious. However, this isn't the kind of thing that anti-harassment orders are for. I can't find that there's been a pattern of conduct directed at a specific person that is serious enough to cause them substantial mental or emotional distress. And all I can really find is that there's maybe some immature and obnoxious behavior in the form of comments and so forth, back and forth between the parties. But that's certainly not the basis to issue an anti-harassment order and place somebody at risk of being arrested in their own apartment. So, Ms. Kashani, unfortunately, I'm sorry you don't have good neighbors, but that's just the reality that you're in, and I can't issue an order based on the evidence that's been presented here. If this is the beginning of something, or if things continue, if there's any kind of retaliation, you know where the courthouse is, and we'll take a fresh look at it if anything like that happens. Hopefully it doesn't. So for today, the petition for the order will be denied.
Thank you, Your
Ms.
Honor.
Holman has filed a petition for a anti-harassment order against Ms. Gerlach. Just a second here while I bring up my electronic file. There we go. All right, and it looks like, Ms. Gerlach, it looks like this notice was served on you Thursday. Is that right?
Correct. Yes, it was.
Okay, good. And I wanted to confirm that you got your notice. And then it looks like somebody named Brandon Bray filed something on your behalf.
That is my cousin.
Okay, and that looks like that was just put into the file today. Okay. All right, I want to make sure that we have everything. Ms. Holman, you get to go first. Remember, everything that has been placed in the court file in this case is already part of the record. I'm familiar with it. I've read it all. It's not necessary to repeat everything. But if you'd like, you can testify and draw my attention to certain aspects of it, certain exhibits, or if you want to make certain arguments on your behalf, feel free to do that. Ms. Holman, go ahead.
Thank you, Your Honor. So we moved into this townhome over a year ago, and from February to the beginning of August, it was the most peaceful, relaxing place to live. The tenant that was next door had moved out, and Miss Gerlach moved in, and literally from the minute she moved in, it has been nothing but chaos. It's either her screaming at her child screaming, running through the house, constantly making noise. She's constantly escalated. I've tried several times, myself, the landlord, I've had to call the cops. We've all tried several times to speak to Ms. Gerlach nicely and ask her, is there a way you can keep the noise down? Any of those types of things. And for a minute, everything seemed to be okay. And it felt like, okay, we're going to be able to, kind of get along and communicate. And then the next time it happened, she just literally, went off the deep end. And ever since then, it's literally every single time she'll pull in the driveway, blasting her music. And I was advised by the police to get it on video. And so I have security cameras that only cover my property. They do not cover her property whatsoever. It's my front door, my driveway, my side of the backyard, and that's all that's covered by my security cameras. When she pulls up in the driveway blasting her music, I look out the window because anybody would do that, just wondering what's going on. Look out the window, you get flipped off. So I started recording, and then that's the video. One of the videos that you have seen is part of my evidence that I had submitted. Not 5 minutes after that video, she came stomping over to my front porch and beat on my door. And I have also sent in a recording of that as well. It's just escalating. It continues to escalate. She does not want anybody to tell her anything or ask her anything. She's been warned many, many times by myself. She's been told by the landlord. She's been told by the police to knock off what she's doing, and it just continually escalates. And now I'm to the point to where I feel like I have to have protection on myself when I walk out my front door just to get into my car to go to work. It's unnecessary and it needs to stop. I don't care where she lives. I'm not asking for this order to mean that she can't live where she lives. That I really don't care about that. I really just want her to knock it off and act like a productive adult and, you know, have conversations and, you know, not be so violent and all constantly cussing at me and flipping me off and calling myself and my husband names. Her family members have also called my husband names. It's just, there's so much. It would just take literally hours to sit and go through all of the things that have led to this point.
Okay. And like I said, everything else that you've filed in support of this has already been reviewed and part of the record in the case, including the videos. All right, Ms. Gerlach, you want to tell me your side of it? And I did, just so you know, I did review the statement that was filed by Brandon Bray.
Okay. Yes. So yes, Your Honor, I moved in about 6 months ago, and from day one, I kind of knew that this probably wasn't going to be the best fit for me because it has just been kind of a nightmare since day one. These people, not Miss Holman and her husband, they go to bed early, and I understand that. I have a 2-year-old daughter, Your Honor. I just got out of a domestic violence shelter, moving into this place, thinking that this was going to be my safe haven, that I had somewhere to live, somewhere to be, somewhere to raise my daughter. And they, from the beginning, they, noise. I don't want to hear a crying baby either. I don't want to hear a crying baby. We haven't even been able to sleep in our beds for, I think, approximately 2 months now, because we sleep in the living room, not trying to wake them up. And I don't want to. I feel like I come home and she's in the window, just constantly watching me. And if somebody comes over, she's watching them. If I have a DoorDash or something, someone deliver milk or whatever is coming to the door, they're constantly out there just trying, or I'm sorry, not Miss Holman, but Mr. Holman is trying to intimidate my visitors. I feel like I'm almost living in a fishbowl, like I am being stalked. Like it's to the point where I don't want to be there either. It's but this is where I live, and I don't want to be intimidated, but it is taking a toll on me and my life. And I've not engaged in any of this. The one time that I went on their side of the property to knock on their door was to kind of see why she was in the window filming me, because she does that often. But this was the night after she had called the police on me, and the sheriff came to my door, and he didn't say anything. He didn't warn me about anything. He took my information down to call me, to be able to call me the next time that she calls them. So that was kind of that. And then I've not had any other police contact about it. And my landlord, that's a completely other story, but he hasn't warned me. He did try to warn me, but I've been working with Safe Place and the advocates the entire time, and they kind of have taken over for me to have to deal with him. So her husband has come over. He's been very aggressive. He's been in my face. He's called me names. I've never called them any name at all, not a single name, and I've never been violent because I come from domestic violence. I'm trying to raise a 2-year-old daughter, like my baby. And yeah, of course I yell, but I'm a mom, and it's not often, but when I do and I'm frustrated, it's because of, I know I'm trying to keep her quiet and pacify my daughter and keep them happy as well. And it's been hell, to tell you the truth. It has been hell living next to these two.
All right. Thank you, Ms. Gerlach.
Your Honor, may I reply?
No, I've heard your side of it.
She
And I
brought up
told you that I
allegations
was-
about my husband, and he's sitting
I
right
told
here,
you,
and they're
keep in
100% not
mind-
true.
keep in mind, I already heard your side of it. It's like I told you in the beginning that even if you don't agree with what the other party says, you got your chance to tell me your side of it. Okay, now, Ms. Gerlach, I'm going to tell you this. You know, I heard this case when it came in as a request by Ms. Holman for an order without any notice to you. And I didn't do that because I know that there are always at least two sides to every story. And I didn't find that there was any kind of emergency situation. And I think that's been borne out here by the testimony and by the exhibits that have been filed. But, you know, before I tell you what my ruling is, Ms. Gerlach, you know, I don't know if you watch those videos, but, you know, that's not exactly commendable behavior. I mean, when you act like that, when you pull in your car and when you're flying the bird and, you know, making nasty comments, you're gonna attract their attention. It's almost like it provokes a response. And if you want to be left alone by these people, leave them alone. You know, if you're going to start, you know, their cameras out there, you know that every time that you go in and out, there's going to be probably a recording of it. If you act in a commendable way, you're not going to draw their attention. But when you flip them off and scream a name, you know, that's exactly what they want to hear. And that just confirms in their mind that you're not a good person. And so they're going to keep keeping book on you, and they're going to call the police on you. And the same stuff's going to keep happening. So if you want to avoid this and really, like you told me, you just want to, you know, live your life there without being bothered, then, you know, part of that is how you interact with others. Now, in this case, in any such case, in order to issue an anti-harassment order, I have to be able to find by preponderance of the evidence that harassment has occurred. And that's a course of conduct directed at a specific person that causes that person's serious concern for their mental or physical well-being. And in this case, I don't find that. You know, this is ordinary neighbors who don't get along and don't behave like adults type situation. But that is not the same thing as putting somebody in fear that they're going to be harmed or that anything bad's going to happen to them, other than just the unpleasantness of having somebody next door who, you know, isn't the most pleasant person. That's ordinary life in the world. I can't give you a good neighbor. You can't come to court and then have the court turn your neighbor into a good neighbor. It's not going to happen. Court can protect you from harm or issue an order that says the other person can't harm you, but only if specific findings can be made. And in this case, they can't be made. So the petition for the order is denied. And I'll say what I said before. If this is the beginning of something and things escalate, or if there's any, you know, taking advantage of the situation to try to torment somebody, you know where the courthouse is, you know how this process works. And I certainly hope that it's not necessary to see either of you again under these kind of circumstances.
Thank you, Your Honor.
The order is denied, and that will conclude your hearing for today.
Thank you, Your Honor.